very good morning to all of you. Chief Justice Alok Aradhe, my senior colleagues, Justice Ravindran, Justice Nageshwar Rao, former judges of the Supreme Court, Justice Shyamlan, brother Shyamlan now, right? We've met and it was great interacting with him. He's in the Court of Appeal and a judge in charge of the Arbitration Division of the DIFC Court. Is the mic okay? Right, thanks. Mr. Arif Alunami, Consulate General of UAE, Professor Raju, who I had the privilege of meeting last night. He's the director of the Asian International Arbitration Center, Malaysia. Distinguished guests from abroad and India, friends from the media. It's indeed a privilege to be back in this vibrant city of Hyderabad that beckons me all the time. Ever since I came here in 2021 and departed for Delhi, Hyderabad has always got a warm place in my heart, wherever I am. The occasion is to celebrate the International Arbitration Day amidst this esteemed gathering of dedicated practitioners and stakeholders who represent the vanguard of arbitration expertise and leadership. This unique event has been meticulously organized by the International Arbitration and Mediation Center, Hyderabad, in collaboration with Shardul Amarchand Mangaldas Co, bringing together global experts in the field of arbitration from the Middle East and Asia. The event has been aligned with a firm belief of bolstering arbitration as an ADR, guaranteeing the prominence in paralleling and resonating distinctly within the international legal regime. The arena of international arbitration is dynamic by its very nature. Its hallmark of flexibility allows it to develop, adapt, and upgrade itself in response to the needs of its end users. Recent times have seen an increased focus on the drivers of change such as diversity, technology, environmental considerations, and information security. Though arbitration has gained traction in recent times, it has been in practice in a less structured format since time immemorial. Arbitration has been an inalienable part of India's legal tapestry, with its historical roots dating back to the earliest civilizations. We are all familiar with traders' guilds and how disputes within the members of the guilds were resolved with the intervention of senior members acting as arbitrators. Even in the Middle East, it has the centuries-long commercial history of arbitration. Arbitration, called tahkim, as it is known, tended to be the most relied upon method of dispute resolution since ancient times in the Arab community. If the parties through negotiations failed to resolve their differences over matters such as property, succession, or torts, an arbitrator or a hakam was appointed to resolve them. Hakam was usually referred to as a lawmaker or an authoritative expounder of the normative legal custom. Venturing southeast to the vibrant city-state of Singapore, one must recognize its unique historical tapestry. From its early days, Singapore has valued the principles of communal harmony and consensus-driven adjudication. These foundational values, deeply rooted in the ethos of the multi-ethnic population, has seamlessly transitioned into the modern era. Today, Singapore's embodiment of these principles has propelled it to the forefront, standing out as a global hub for modern arbitration. Its geographical neighbor, Malaysia, is also rooted in the same culture and moorings. These ancient traditions, steeped in the ethos of community participation and consensus building, reflect the unwavering commitment of leading nations of the Middle East and Asia to inclusivity and harmony. The community inclination in the Asia-Pacific region, by and large, is one that continues to converge in favor of arbitration. Alongside the growing number of arbitrations in the region, the governments and courts alike have taken a firm pro-arbitration approach, paving the way for increased adoption of arbitration as a means of dispute resolution. the flavor of arbitration in Asia has been augmented by the generally pro-arbitration stance taken by the countries in the region. Arbitration hubs and institutions in Asia have reached new heights in their growth and popularity, achieving stellar global rankings and an ever-growing number of case filings. As per the 2021 Queen's Mary University of London survey, 3 out of 5 most preferred arbitral institutions in the world are situated in Asia. That is the Singapore International Arbitration Center, the Hong Kong International Arbitration Center, and followed by the China International Economic and Trade Arbitration Commission, ranked at 2nd, 3rd, and 5th respectively. The arbitration institutions in the Middle East have also harmonized their rules as per the global standards by declaring the Dubai International Arbitration Center as a fully autonomous entity and a sole arbitration chamber in the Emirate, after Abu Dhabi Commercial Conciliation and Arbitration Center. Following this, other countries in the Middle East, that is the Saudi Center for Commercial Arbitration, the Oman Commercial Arbitration Center, and the Bahrain Commercial Chamber of Dispute Resolution, have also shown a significant growth of their arbitration institutions. In recent years, India has also made significant strides in establishing itself as a reliable and trustworthy partner in arbitration services. The setting up of IAMC at Hyderabad, which is the newest center on the block, along with other prominent already existing arbitration institutions like the ICA, the DIAC, the MCIA, and the ICC, as also the New Delhi International Arbitration Center, are prime examples of the constructive steps taken towards enhancing ADR landscape of the country. In fact, I would say that there is all the space under the sun for more institutions to flourish in our country. The growing prominence of institutional arbitration in India and even globally points towards the necessity of a specialized arbitration bar comprising of experts and legal practitioners dedicated to arbitration. Such a bar would work in tandem with leading arbitration institutions. This partnership aims to refine the arbitration process, showcasing its efficacy as a primary mode of dispute resolution. In a recent international conference organized by the Bar Council of India at Delhi, where I was invited to chair a session on ADR in international transactions, I had taken the opportunity to highlight the fact that a specialized arbitration bar, particularly in India, will promote a cultural shift in the legal community, positioning arbitration as a niche field of expertise. It will attract fresh talent and at some stage, perhaps, call for specialized arbitration tribunals at high courts and district levels, akin to commercial benches. Regular workshops and training sessions will streamline every facet of arbitration process, from drafting to enforcement. These measures will help boost both domestic and international confidence in India as an arbitration hub. This will also ensure that arbitration gains primacy and does not take a back seat as compared to litigations in court. Such a dedicated arbitration bar will help in adhering to fixed timelines, to quick disposals, and not mirror court proceedings. One example of such a bar is the International Bar Association Arbitration Committee, the IBA committee, that focuses on laws, practice, and procedures relating to arbitration of transnational disputes. Therefore, what is perhaps a must for strengthening the process of arbitration in India is promoting a strong and experienced cadre of arbitrators and a specialized arbitration bar. Incidentally, just a couple of weeks ago at the IIAC conference, Mr. Venkat Ramani, the Attorney General of India, has announced creation of an all-India arbitration bar, which is indeed a step in the right direction. Coming to Indian judiciary's support to arbitration, it is imperative to recognize that the essence of justice lies not only in honoring the arbitral awards, but also in safeguarding the interests of fairness and equity. In this context, India's judiciary's unwavering support to arbitration process must also be underscored. Judicial intervention on grounds of patent illegality or public policy is treated as an exception to the rule. Guided by the principles of party autonomy and minimal interference, the Indian judiciary exercises prudence and restraint in interfering with arbitral awards. Recently, in the case of Gemini Bay transcription, dealing with the issue of enforcement and recognition of a foreign award under Part 2 of the Arbitration and Conciliation Act, the Supreme Court has held that foreign awards could be binding against non-signatories to the arbitration agreement. As the landscape of arbitration evolves and new challenges emerge, our judiciary has also adapted and responded to the changing needs of the hour and refined the contours of judicial intervention. In the notable case of Balco, the Supreme Court affirmed the pro-enforcement stance of Indian courts. It was observed that the Indian judiciary should adopt a minimal intervention approach while dealing with arbitration awards. It was emphasized that courts should only act as an appellate authority and refrain from reassessing merits of the arbitral award unless there are compelling reasons to interfere. This has conveyed a strong message to the global business community that India is committed to maintaining the sanctity of arbitration. The Indian judiciary's commitment to enforcement of arbitral awards is equally unwavering. As recently as in the end of September 2023, last month, a 5-judges bench of the Supreme Court has referred the NN Global Mercantile case to a 7-judges bench for reconsideration of the primary issue of whether an arbitration clause forming a part of an insufficiently stamped agreement can be acted upon or not. Quick to note the ripples created in the ADR circles by the NN Global judgment, and having regard to its larger ramifications, the Supreme Court has taken a more pro-arbitration stance by promptly referring the matter to a larger bench for further deliberation. I would like to now touch upon the gender-based diversity in arbitrations. Another significant issue that needs to be flagged is the lack of diversity, including gender diversity among international arbitrators. Gender-based diversity in arbitrators is essential for promoting inclusivity and fairness in the field of dispute resolution. In 2019, the Cross-Institutional Task Force on Gender Diversity in Arbitral Appointments and Proceedings, in short, the task force, was established by 18 leading international arbitration institutions, gender diversity initiatives based on NGOs and law firms to analyze and publish recent statistics on the appointment of female arbitrators and to identify opportunities and best practices to promote gender diversity in international arbitration. In last year, in September 22, the task force launched the 2022 update of its report on gender diversity in arbitral appointments and proceedings that analyzed the data provided by 14 arbitration institutions worldwide that are members of the task force, including the International Court of Arbitration and of International Chamber of Commerce, the International Center for Dispute Resolution, and the London Court of International Arbitration. This report found that before the year 2015, women were a minuscule fraction of arbitrators. They accounted for 5 women, 3.5%, in the population of 145 investment treaty arbitrations, and that there were no tribunals composed of 2 or more women. However, there has been a significant improvement in recent years. Between 2015 and 21, the percentage of women appointed as arbitrators has nearly doubled from 12.6% to 26%. Arbitration institutions must be credited for having played a significant role in driving this trend. Between 2015 and 2020, at least a quarter of all the appointments by arbitration institutions have been of women, increasing their share in the pie from 24.9% in 2015 to 37.9% in 2021. For co-arbitrator appointments, the percentage of women appointed has nearly tripled from 10% in 2015 to 27% in 2021. In recognition of this underrepresentation of women on international arbitral tribunals in the year 2015, members of the arbitration community drew up ERA. ERA stands for Equal Representation in Arbitration Pledge. To take action, the pledge seeks to increase on an equal opportunity basis the number of women appointed as arbitrators, in order to achieve a fair representation as soon as practicably possible, with the ultimate goal of full parity. The pledge's reach continues to expand into new regions, and various arbitration centers have actively made an effort to sign the pledge, including the Saudi Center for Commercial Arbitration, the Mumbai Center for Commercial Arbitration, and the Singapore International Arbitration Center. Leading countries in the world of international trade and commerce are actively opting for arbitration while striving towards the adoption of global standards of gender parity. One such example that comes to the mind is of the Saudi Arabia, where the Saudi Administrative Court of Appeal had approved appointment of the first Saudi female arbitrator in the field of commercial disputes as long back as in May 2016. Even in Dubai, which has emerged as a world-class center for international trade due to its liberal economic regulations and business-friendly policies, the diversity in the boardrooms and an increasing number of women investors are contributing to a more diverse and inclusive startup opportunities. I have personally witnessed the vibrant ecosystem of arbitration in Dubai last year when we had participated in a delegation from the Supreme Court in International Conference on Arbitration hosted by FICCI. The UAE hosts a thriving ecosystem of women-led funds, angel networks, and accelerators, with different funds opening operations to focus on investing in women-led startups. I'm sure similar progressive initiatives will be taken up by the UAE in the field of arbitration as well, and women arbitrators will account and be accorded equal accreditation and recognition. There are several other ways to promote women in the field of arbitration. Arbitration institutions must develop systematic and collaborative strategies in key areas. These include enhancing education and training through scholarships for women, representatives of other underrepresented groups, and revising institutional arbitration rules to appoint diverse arbitrators, particularly women, a standard practice in the selection process. Additionally, increasing awareness activities like this one that is being hosted today by IAMC must be undertaken on a regular basis to update all stakeholders in international and domestic arbitrations, including parties, general counsel, litigation lawyers, and arbitrators, to bring a balance in making the appointments. In conclusion, for achieving an equitably diversified and globally attuned arbitration framework, it is imperative to promote the fusion of ancient wisdom, replete in the Middle East and the Asian regions, with contemporary advancements and a constant pursuit of impartiality, of innovation, and broad consensus. Collaboration is vital in our onward journey towards fostering an environment of mutual respect, multicultural sensitivity, and unwavering commitment to upholding the sanctity of arbitration. This will contribute constructively to the global legal narrative. We must also remember to meld our rich historical practices with modern innovations, giving primacy to principles of party autonomy, to fairness and inclusivity. As we stand at the crossroads of tradition and innovation, let us reaffirm our shared vision for a brighter and harmonious future of global arbitration. Let us cultivate an ecosystem of respect and commitment to the core tenets of arbitration. My compliments to the organizers for providing a platform for a constructive dialogue and insightful deliberations planned for the day, with experts from India and abroad in the field forming a part of the panels. Thank you for your attention.